Over the past 4 years, schools in Massachusetts have been required by state law to reduce the number of students left behind because of disciplinary practices. As a result, the number of out-of-school suspensions has decreased in district public schools and charter schools. But a report from Lawyers for Civil Rights Boston shows continuing gaps between types of public schools and types of students. To tell us about the report is the group's Civil Rights Fellow, Lauren Sampson. Thank you very much for being with us, Lauren.
Of course, it's a pleasure to be here.
Lauren, go back a little bit here before this state law. What prompted that law and what was going on in the schools?
Of course. So the initial report that our organization published looked at data from the 2012-2013 school year. This is right before the law came into effect in July 2014. What our organization found was quite startling. Taken as a whole, Massachusetts students lost 200,000 days of school over the course of that year. Most of those infractions, something like 2/3 of them, were for minor offenses. These are non-violent, non-drug, non-criminal offenses. The schools were resorting to practices like out-of-school suspensions much more quickly for students of color, students with disabilities, and English language learners than they were for their peers. There wasn't any kind of consideration of alternative measures, for example, restorative justice, mediation, peer-to-peer counseling, even though these measures have been shown to be far more effective at actually improving student behavior and maintaining their connection to the school. This paralleled an effort at the federal level that was concerned about the civil rights violations implicit in this kind of disciplinary practice. When African American and Latino children are being disciplined at a far higher rate, that increases the likelihood that they enter that school to prison pipeline. A higher rate of disciplinary measures means a student is far more likely to drop out of school and then far more likely to get into trouble later in life.
Well, you know, when I was in high school, if somebody got suspended for one day or a few days in the course of a year, I wasn't sure that was a big deal as far as learning, but put that in context. What's going on with a kid who's experiencing that?
A student who's been taken out of class experiences a couple of different measures. The first is a sense of disconnect from that community, a sense that their concerns aren't necessarily being addressed. And that's especially true for the nonviolent, non-drug, and non-criminal offenses. Our organization profiled cases including students speaking up about no talking in the hallway policies, who then receive a suspension. If a student also sees that they're being treated differently from their peers, that can also decrease the connection they feel to their school district or to their classroom. There's also this sort of negative reinforcement element. If a student is being truant or is misbehaving in class and then they're told you can't come to class, that doesn't exactly incentivize that student to try harder at school if the reward is going to be being taken out of school. Those days of lost instruction mean that when students do eventually come back, they're behind their peers, they feel out of place, they're not quite in sync with the rest of the school year, making it far more likely that they drop out or that they have other kinds of behavioral interactions either with the school or outside of it.
Now, you know, when kids are disruptive, I guess it's common to hear someone say, well, their parents didn't do a good job of bringing them up. But on the other hand, when kids are processing what's going on around them, let's say processing incarceration in the family, couldn't that also be one of the things prompting a problem in the classroom?
And that's one of the reasons why mediation, restorative justice, positive behavioral interventions can be so much more effective. Rather than simply removing a troublesome student from the classroom, for example, for a zero tolerance policy, you don't really get to what's underlying the student's reason for their disruption. Something like restorative justice, which would encourage the student to sit down and think about the relationship to the school, the relationship to a victim, if any, and how to really repair the harm, makes it less likely that they exhibit those troublesome behaviors in the future, and making it more likely the school is able to target the actual reason behind the disruption.
Another thing that crosses my mind is that even if we're not talking about students with certifiable learning disabilities, you might have students, you know, like with a lot of adolescents, they have mental health issues. What about those students?
One of the findings in our report was that schools that have high percentages of students with learning disabilities, Therapeutic Day Schools, for example, were exhibiting extraordinarily high numbers of out-of-school suspensions, expulsions, or other kind of exclusionary discipline. The suggestion to us is then that those schools who are taking on students with incredible needs aren't really meeting those needs adequately if the response is just to remove them from the classroom. Some Therapeutic Day Schools were seeing students students removed from the classroom at rates at over 50%. The idea that you could be suspending over 50% of your students doesn't suggest that suspension is working as a mechanism to engage with those students' particular needs.
This is BNN News. We're talking with Lauren Sampson from Lawyers for Civil Rights, Boston. Lauren, there are also some positive trends here. In the first place, it seems that these out-of-school suspensions are down quite a bit, aren't they?
In the initial year after Chapter 222 was passed, that's true. We do see a decrease in these exclusionary disciplinary practices. In the state as a whole, Massachusetts had been seeing something like 5.4% of all students with at least one exclusionary disciplinary measure. Now that number is down to around 4%, and that's certainly an important decrease. I will say, however, that that number seems to have plateaued. There was a decrease in the initial year after the law was passed, but that number hasn't been steadily dropping. We also continue to be concerned about areas where you do still continue to have students being given exclusionary discipline at a higher rate than they should. Latino students, for example, are given exclusionary discipline at a far higher rate, not only than white students, but also a rate higher than the national average. So high not just within Massachusetts, but high in the country as a whole. And that remains true for students with disabilities, English language learners, and Black and Latino students.
Speaking of gaps, I see a pretty sizable gap still between the Boston Public Schools district-wide and charter schools. What about that? That
is something that was highlighted both in the previous report and in the current report, that charter schools in particular were seeing really high rates of discipline. In particular, Roxbury Prep, a charter school not too far from here, prior to the passage of Chapter 222, had suspended something like 68% of all its students, and almost all of those were for nonviolent, non-drug, and non-criminal offenses. That number has dropped. It's just under 30% now, but that's still incredibly high, and 86% of those are for these minor infractions. And when I say nonviolent, non-drug, non-criminal offenses, this can be anything from a dress code violation to talking in the hallway to a teacher's subjective interpretation of disruption in the classroom.
Now, we had one guest on from a charter school, and I guess his message was you can be more attentive to things like trauma and social and emotional well-being, but at the same time, maybe you need to suspend students if they're wearing a hat in school. I mean, couldn't that be the case maybe?
So the response to that would be that Chapter 222 specifically required schools to look at exclusionary discipline as a last resort, that they should, prior to that, consider other measures for disciplining a student, particularly if the offense is not disruptive or not dangerous. This has been a particular concern in the area of emergency removals. This was something created by Chapter 222, where pending an investigation or hearing, a school can remove a student from the classroom if their behavior is incredibly disruptive, pose a danger to other students, and there's no way to maintain them in the classroom. These removals have skyrocketed following 222, and our concern is that in cases like you're describing, a student is wearing a hat when they shouldn't, there isn't really a threat to school safety or classroom disruption. And so prior to looking at a suspension, a school should be looking at every possible alternative rather than instantly moving to take a student out of class.
Thank you very much for being with us.
Of course, thank you very much.
Lauren Sampson from Lawyers for Civil Rights, Boston. In a moment, a local protest against a local company providing weapons for a deadly conflict in the Middle East. But first, this message.